Hello again everyone, Prosecutor Fabriga here. Today we are going to discuss about inquest. Daghan kayong mga misconceptions aning inquest, no? And I think this is of particular importance not just for law students but also for our law enforcers. Daghan-daghan pang mga law enforcers nga wa kasabot unsa ning inquest or how a prosecutor is supposed to conduct an inquest proceeding. So hopefully, at the end of this video, mas masabtan nato og klaro kung unsa gini siya ang inquest. And inquest is based on Rule 112, Section 7 of the Revised Rules on Criminal Procedure. So ako ni siyang gimugna in a Q&A format para mas masabtan niya. Mura siyang step-by-step procedure ba on how to conduct an inquest from the viewpoint of a prosecutor. So here it is. Again, we have our usual disclaimer. This lecture is just a supplement to your study of criminal procedure. Attention, law students. It does not seek to supplant your reading materials nor contradict what your professors have discussed to you about the subject matter. I'm just sharing this drawing from my experience as a prosecutor for the last 11 years. Take a look at this familiar scenario. Let us suppose X, a police officer in his presence, nakita niya si Y nga iyang gidunggab si B. No? He saw Y stab Z. Before Y could escape, X arrested him. Under the law, X is allowed to arrest Y even without a warrant of arrest because Y committed the crime in his presence. So, kani nga scenario nga akong gidepict diri is one of those instances of a valid warrantless arrest. I am talking about in flagrante delicto arrest. Now the question is, after X arrests Y, what should X do with Y? Human nga giaresto na ni X si Y, unsa may sunod nga buhaton ni Y? Pick your choice. Letter A, should the police officer release Y and allow him to go home? Or B, should the police officer imprison Y for a few days and then release him afterwards? C, should the police officer bring Y to the priest to make him confess to the crime? Or letter D, should the police officer bring Y before the fiscal for purposes of inquest? I think the answer to this question is very obvious, no? The police officer should what? Bring the arrested person before the fiscal in order for the latter to conduct an inquest proceeding. Now, unsa man ning inquest proceeding? An inquest is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested without warrant for the purpose of determining whether or not said persons should remain under custody and correspondingly charged in court. Now, at this juncture, take note of the keywords of the definition of an inquest. Take note of the word informal and summary investigation. And then take note of who conducts the inquest, public prosecutor, ang nature sa case, criminal cases, and then the persons covered by the inquest, katulang mga persons nga arrested without warrant. We will dissect this definition in the succeeding slides. Okay? First question. Under what instance does an inquest take place and for what purpose? Take note of this. It applies only in those cases involving persons who are arrested without warrant. Kato bitong mga cases nga covered under Section 5, Rule 113 of the Revised Rules on Criminal Procedure. No? Just for purposes of revisiting that particular provision in the Rules of Procedure. Okay? The inquest prosecutor at this instance shall determine if the arrest of the detained person was made in accordance with any of the following. Number 1, when in the presence of the arresting officer, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. I am referring to the so-called in flagrante delicto arrest. Kanang makita ninyo nga italicized portion sa slide. Second instance, when an offense has in fact just been committed and the arresting officer has probable cause to believe based on personal knowledge of facts and circumstances that the person to be arrested has committed it. Okay? This is called, in short, a hot pursuit arrest. And the third instance is when the person to be arrested is a prisoner who has escaped from a penal establishment where he is serving final judgment, or he is a detention prisoner temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. I am talking about escapees. So, again, take note of the persons covered. Okay, it applies only to those persons who are arrested without warrant under the circumstances provided for in Section 5, Rule 113 of the Revised Rules on Criminal Procedure. Now, in my previous video, I already discussed, I made examples on these three instances. So, please take the time to listen to the video, which I also or already posted in this channel. What about the purpose of an inquest? The purpose of an inquest is to determine whether or not, number one, the person arrested without warrant should remain under custody. Naabay basihan nga dapat siyang i-detain. And kung dapat siyang i-detain, naabay basihan nga valid ang iyang arrest. Because that is the first question that a prosecutor should determine, whether or not his arrest was made in accordance with the circumstances or instances of a valid warrantless arrest under Section 5, Rule 113 of the Revised Rules on Criminal Procedure. And then the second purpose of an inquest is for the prosecutor or the inquest fiscal to determine whether or not the person arrested without warrant should be correspondingly charged in court for the alleged commission of a crime. Now, who conducts an inquest and how is it conducted? The public prosecutor or the fiscal is the government official mandated and authorized to conduct an inquest. And remember what I told you when we defined what an inquest is. An inquest is just an informal and summary investigation. Informal meaning it is not bound by the technical rules of procedure, and summary meaning it is not a trial type proceeding. In an inquest, the prosecutor will only determine whether or not there was a valid warrantless arrest and whether or not there is probable cause to file a case or an information against the arrested person for the alleged commission of a crime. Now, let me give you an idea what happens during an inquest proceeding. So, it is not just the arrested person ang dadun dito sa police officer. Of course, the police officer must also prepare and file a written complaint. So, katong written complaint niya, he will attach in the written complaint his affidavit of arrest, his investigation report, the sworn statements of witnesses, if any, and then other supporting evidence or supporting pieces of evidence gathered by the law enforcement authority in the course of their investigation. So, i-file na nila dito sa among opisina and then it will be received by our docket clerk. And then once it has been received by our docket clerk, the prosecutor will then commence the inquest investigation. So, the first thing that the prosecutor or the fiscal should do is to ask the arrested person, "Sir, naa ba kay abogado?" And I am not just talking about any lawyer. I am talking about the lawyer as chosen by the arrested person. Kay required man na sa atong constitution nga the lawyer that should represent the arrested person must be a lawyer of his own choice. Okay? But if the arrested person cannot afford the services of a lawyer of his own choice or doesn't have one, it is now the obligation of the fiscal to provide him with one. The fiscal will then suggest that the arrested person be brought to dapaw lawyer concern, no, naaman tayong mga abogado sa gobyerno, kanang gitawag nilang mga public attorneys, no. Usa ni sa ilang mga functions during inquest proceedings, no, to assist arrested persons during inquest investigations. Now, let us say the arrested person is already represented by a lawyer of his own choice or by the public attorney's office. The prosecutor will then proceed to determine whether or not there was a valid warrantless arrest. Now, how will the prosecutor determine whether or not there was a valid warrantless arrest? He will of course interview or ask questions towards the arresting officers, no? Mga informal questions lang, no? Para lang makahatag lag enough assessment on the part of the fiscal nga sige, the arrest was valid or the arrest was made in accordance with Section 5, Rule 113 of the Revised Rules on Criminal Procedure. So informal na siya, no? Wala na siya technical rules nga dapat mo follow pa ka og certain rule una ka maka-manifest or before an arresting officer could say something to the fiscal. No. It's just like a normal conversation between a fiscal and the arresting officers. And summary, because it is not a trial type proceeding. Wala man ta sa korte. We are just in the fiscal's office, and then the fiscal is merely asking questions on the arresting officers and of course on the witnesses that the arresting officers have produced. Okay? For the purpose of determining whether or not there is probable cause to file a case or information against the arrested person for the alleged commission of a crime. So, mo na siya ang pasabot sa informal and summary investigation. Does the arrested person have the right to be assisted by a lawyer during the inquest proceeding? The answer to this is an obvious yes. As I've already emphasized, the person arrested must be assisted by a lawyer of his own choice. If he has none, then the fiscal shall provide him the services of a lawyer from the public attorney's office. They are also government lawyers just like fiscals, and their services are for free. This is what? This is in compliance to a person's constitutional right to be assisted by a competent and independent lawyer, preferably of his own choice. Now, you might ask, kinahanglan yun ay fiscal nga na ay lawyer nga maka-assist sa katong mga gipang-aresto without warrant during an inquest proceeding? Yes, kinahanglan. Why? Because kani nga mga lawyers sa public attorney's office or any lawyer for that matter who is the choice of the arrested person to represent him during an inquest proceeding, sila mo'y makahatag og advice, proper advice to the arrested person as to what to do with his case. Sila mo'y mo check dito sa affidavit, sa complaint kung naabay ground to object, naabay ground to raise an objection or question the arrest of the arrested person. So sila mo'y maghatag og advice, and then sila po'y mag-determine kung angay pa ba motubag ang katong arrested person by asking for a preliminary investigation or kung isubmit na lang ba ang kaso for resolution by the prosecutor or the inquest prosecutor concerned. So, importante kayo ang ilang presence during the inquest proceeding. Now, what are the crimes subject to inquest proceedings? Take note of this. As a general rule, all crimes under the Revised Penal Code and Special Penal Laws are subject to inquest proceedings whether or not the crime committed requires a preliminary investigation. So, tanang offenses, tanang crimes, okay, pwede siya ma-subject to inquest proceedings for as long as it comes under the circumstances of a warrantless arrest under Section 5, Rule 113 of the Revised Rules on Criminal Procedure. Are there exceptions? Yes, of course there are. What are these exceptions? Inquest is not required for the following: violations of traffic laws, rules, and regulations, violations of municipal or city ordinances, and all other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 6 months, like slight physical injuries, unjust vexation, grave threats, slight oral defamation, etc. Now, let me give you an example. Let us suppose X, a driver of a vehicle, parked the vehicle in an area where parking is prohibited. Now, he was seen by a traffic enforcer parking the said vehicle. Question: can the traffic enforcer effect a valid warrantless arrest because a crime was committed in his presence? Unsa ba tong crime nga na-commit sa iyang presence? Violation of a traffic regulation by parking in an area where parking is prohibited. The answer is no. No. A warrantless arrest is not necessary with respect to these exceptions. Kaning mga mere traffic violations, kaning mga violations lang of municipal or city ordinances, they need not be arrested and they need not be brought for inquest. Again, please remember that an inquest presupposes that there is a warrantless arrest. Without a warrantless arrest, there is no inquest to speak of. They go hand in hand. Okay? So, kung ang crime nga na-commit kan mo fall ani nga mga exceptions, to repeat, violations of traffic laws lang, violations of municipal or city ordinances, and kaning mga criminal cases nga ang penalty imposable does not exceed 6 months, dili sila kinahanglan i-subject to an inquest proceeding. Why? Because they need not be arrested without warrant. How can they be held liable? They can be held liable by filing a case in the regular procedure, not subject them to an inquest proceeding. Question: what if the person arrested is a minor? Shall he be subjected to an inquest proceeding? The answer is it depends. Remember that if the minor was exactly 15 years old and below at the time of the commission of the crime, then that minor has no criminal liability. Same goes for a minor above 15 but below 18 who did not act with discernment at the time of the commission of the crime. That minor also has no criminal liability. If the minor was above 15 but below 18 who acted with discernment, it depends. If the crime committed by the minor is punishable by imprisonment of more than 6 years, an inquest shall be conducted provided that no inquest investigation shall proceed unless the child respondent shall have first undergone the requisite proceedings before the local social welfare development officer pursuant to the rules on inquest with respect to children in conflict with the law. Like for example, the determination of discernment. No? Adto ginauna, no, ipadala dito sa local social welfare officer, and then it will be the local social welfare development officer who will determine whether the child acted with discernment in the commission of the crime. If the crime committed by the minor who acted with discernment does not exceed, or the penalty imposable for the crime committed by the minor who acted with discernment does not exceed 6 years imprisonment, still he will not be subjected to an inquest proceeding but he will be subjected to a diversion program. Adto ra gyapon na didto sa LSWDO. As much as possible, hands off ang prosecutor when it comes to minors, no? Especially minors who commit crimes where the penalty imposable does not exceed 6 years. When and where should an inquest be conducted? Kanus man dapat mag-inquest ang fiscal o asa man pud siya mag-inquest? The rule states that inquest proceedings may be conducted at any time of the week, Monday to Sunday, 24/7. However, where an inquest falls on a non-working day, Saturday, Sunday, or holiday, and a prosecutor is not available on those days, then the inquest proceedings may be conducted on the first office day following the arrest. Now, the general rule here is that an inquest should be conducted right after the accused is arrested or as soon as possible. Let us say the accused was arrested on a Saturday morning. As much as possible, after a few hours, after the police officer is able to prepare the necessary documents for the filing of an inquest complaint, the arresting officer must forthwith bring the arrested person to the fiscal's office so that the fiscal can right away conduct the inquest proceeding. So, let's say Saturday afternoon. If the fiscal is available on a Saturday afternoon, kinahanglan maka-inquest dahil ng fiscal because unsa may gi-avoid ana. The rule requires that the inquest proceedings to include the filing of the information in court if warranted must all be completed within the 12, 18, or 36-hour reglementary period provided for in Article 125 of the Revised Penal Code. When I say 12, 18, or 36-hour reglementary period, it depends on the nature of the crime alleged to have been committed. Let us say, for example, ang crime nga na-commit is murder. Under the law, kung murder ang gi-commit and which was the reason why the person was arrested without warrant, the rule requires or the law requires that the inquest proceeding to include the filing of the information in court must be completed within 36 hours because murder is a grave offense. 36 hours I mean. So kinahanglan within 36 hours from the time of his arrest dapat makumpleto na, mahuman na ang inquest proceeding, and then if it warrants nga an information should be filed, the filing of the information must also be made within the 36-hour reglementary period. That is the reason why the law requires that as much as possible, the inquest should right away or immediately be conducted. Now, the rule I am showing you here in this slide is more of the exception because if the arrest fell on these days or falls on these days, pwede ra maka-inquest ang fiscal if he is not available on those days on the first office day following his arrest. Now, in that example, the person was arrested on a Saturday. What is the first office day after Saturday? Sunday? No. It will be Monday. So, the prosecutor or the fiscal is allowed to conduct the inquest on a Monday even if it already goes beyond the reglementary period provided for in Article 125 of the Revised Penal Code. That is what is meant by this rule here. Now, unless otherwise directed by the provincial or city prosecutor, the inquest must be conducted where? At the fiscal's office and not at any other place. Not at the fiscal's office and neither at the police station where the arresting officers are stationed. Now, how does the fiscal determine the legality of the arrest? The fiscal shall determine the same by checking if it falls under any of the instances of a valid warrantless arrest under Section 5, Rule 113 of the Revised Rules on Criminal Procedure. What are the instances of a valid warrantless arrest? In flagrante delicto arrests, hot pursuit arrests, and in the case of escapees. Now, I will no longer discuss them again to you in detail because I have already made an extensive discussion on this in my previous video. So please take the time to listen to that video so it will better your understanding as to what these instances of a valid warrantless arrest are. What happens if the fiscal finds that the warrantless arrest was not properly effected? Imagine here a situation where the inquest has already started and the fiscal, after interviewing the arresting officers, after reading the complaint, the affidavits of the arresting officers as well as the affidavits of the witnesses, if any, finds that the warrantless arrest was not proper, the fiscal shall recommend the release of the person arrested or detained, subject of course to the approval of the prosecutor general or of the city or provincial prosecutor having supervision over him. So in my case, I am a fiscal assigned in the province, assigned in the office of the provincial prosecutor. In our office, we have one chief of office. He is called the provincial prosecutor. Under him are all assistant provincial prosecutors. Now, in my case, if it so happens that the warrantless arrest of the person brought before me for inquest was not properly effected, I will have to make a resolution recommending the release of the person arrested and then forward it to my provincial prosecutor, and in case he approves of the same, I will be furnishing a copy of this resolution to the arresting officer concerned or the police officer having custody of the person arrested. For the purpose of what? Informing him or ordering him that he should release the person arrested because there was no reason to effect a valid or a warrantless arrest. However, where the recommendation for the release of the arrested or detained person is approved, but the evidence on hand warrants the conduct of a regular preliminary investigation, the fiscal shall still order the release of the arrested person and serve upon him a subpoena together with a copy of the complaint and its supporting evidence, requiring him to answer the charge within 10 days from receipt thereof. So, same example. Para nakita nako nga the arrest was not valid. So, I recommended the release of the arrested or detained person. But at the same time, I also found that the evidence on hand warrants the conduct of a preliminary investigation, regular preliminary investigation, because there are instances, class, nga what is only invalid is the arrest. But there is what? Some ground to continue with the investigation. If such is the case obtaining, I will then what? Convert what was once an inquest case to one of regular preliminary investigation, such that I will be issuing a subpoena to the person arrested, requiring him what? To submit his counter affidavit within 10 days. Kay ako naman siyang convert into a regular preliminary investigation case. So at first, mura siya inquest case, but since in my assessment, the arrest was not valid such that I recommended his release, but at the same time, I found something that warrants a regular preliminary investigation, I will have to continue with the investigation, but this time, dili na siya as an inquest case, but as a regular preliminary investigation case wherein the person who was ordered released will now have to submit a counter affidavit within 10 days from his receipt of the subpoena I issued to him. So, mo continue siya ang investigation but the person was already released while the investigation is ongoing. Now, what happens if the fiscal finds that the warrantless arrest was properly effected? Let us say, for example, the fiscal, after reading the complaint, as well as the affidavits of the arresting officers and the affidavits of the witnesses produced by the arresting officer, finds that the warrantless arrest made on the person arrested was valid, he will then have to ask the person arrested if he desires to avail himself of a preliminary investigation, of course with the assistance of his counsel. So his counsel will then have to assess whether they will still answer the charge through a preliminary investigation. What is a preliminary investigation? A preliminary investigation is merely a proceeding whereby the prosecutor will determine the existence of probable cause after giving the arrested person an opportunity to submit his counter affidavit or any evidence he may produce within 10 days from the day he was brought for inquest. This preliminary investigation shall be terminated or completed within 15 days from its commencement. So, ang kini di ang preliminary investigation, opportunity lang ni siya given to the arrested person, allowing him to submit his counter affidavit denying the charge or disproving the charge against him. And then after the arrested person submits his counter affidavit, or let's say if he does not submit or he is not able to submit his counter affidavit within 10 days from the day he was brought for inquest, the prosecutor within 15 days will have to determine whether or not there is probable cause to file a case against him in court. If the prosecutor does not find probable cause to file a case against him in court, then the prosecutor will issue a resolution dismissing the complaint against him. But what is probable cause? A probable cause or probable cause for purposes of filing an information or a criminal case in court has been defined as such facts as are sufficient to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. This is only what? Kaning gitawag class nga probable cause is the quantum of evidence required in preliminary investigation cases. This is different from the quantum of evidence required during trial when the case has already been filed in court, because in court, the quantum of evidence required there is proof of guilt beyond reasonable doubt. But for purposes of preliminary investigation before the fiscal, the quantum of evidence required is only probable cause, probability. Okay? Naabay probability nga a crime has been committed. Okay? Are there facts sufficient to engender the probability that a crime has been committed and that the respondent is probably guilty thereof? For which reason, there must be a case filed against him in court. That is the only duty of the prosecutor or fiscal during a preliminary investigation. That is, to determine the existence of probable cause. Naabay igong basihan nga filean og kaso ang respondent based on the evidence submitted before him. However, if the arrested person wishes to avail of a preliminary investigation, he must first sign a waiver of the provisions of Article 125 of the Revised Penal Code, which was what I discussed a while ago. The question is, why does the arrested person have to first sign a waiver of Article 125 before he can avail of preliminary investigation? Article 125 mandates that the inquest proceedings, to include the filing of the information in court, must be terminated or completed within the 12, 18, or 36-hour reglementary period counted from the time of the arrest. So, it must be terminated within 12 hours in the case of light offenses. Meaning to say, depending on the nature of the crime committed, kung light offense lang, the reglementary period is only 12 hours counted from the time of the arrest. Kung less grave offense lang, the reglementary period is only 18 hours counted from the time of the arrest. Or If the crime alleged to have been committed by the arrested person is a grave offense like murder or homicide or violation of the dangerous drugs law, it is considered as a grave offense, for which reason the arresting officer as well as the fiscal is given what? 36 hours from the time of the arrest to complete the inquest investigation and to include the filing of the information in court. What do I mean by to include the filing of the information in court? The filing of the information in court must be made within the said reglementary period, counted from the time of the arrest. So for example, the person was arrested at 12 o'clock noon on a Monday, and the crime alleged to have been committed by the said person is murder. So the reglementary period is 36 hours, counted from the time of the arrest. So how many hours or until what time should the prosecutor complete his inquest investigation to include the filing of the information in court? So, to repeat, the person was arrested at 12 o'clock noon on a Monday. You add 24 hours. It is 12 noon on a Tuesday. You add another 12 hours because the reglementary period is 36 hours. It will lapse on what? On midnight of Tuesday. So, the inquest proceeding as well as the filing of the information in court must be made within the 36-hour reglementary period, because if no information is filed within the 36-hour reglementary period and the police officer continues to detain the arrested person, there is a possibility that the arresting officers might be held liable for arbitrary detention under Article 125 of the Revised Penal Code. If no information is filed within the 12, 18, or 36-hour reglementary period, the police officer detaining the arrested person must release the latter. Otherwise, the police officer will be liable for arbitrary detention if he continues to detain the arrested person beyond the 12, 18, or 36-hour reglementary period. That is the reason why the arrested person, if he wishes to avail of preliminary investigation, must first sign a waiver of Article 125 so that the police officer detaining him will not be liable for the crime of arbitrary detention, considering that a preliminary investigation takes at least 25 days to be completed. Diba? Ang katong mga reglementary periods, 12, 18, or 36 hours raman. And then if the arrested person asks for preliminary investigation, mo take man lang 25 days to be completed at the very least, mulapas na siya. So by the time nga mag-resolve na ang fiscal, klaro na kaayo nga ni-lapse na or ni go beyond na siya sa 36 hour ang pinakataas pagani, no? Ni go beyond na siya sa 36-hour reglementary period. So para dili siya maka-violate sa Article 125, ang katong arresting officer having custody of the arrested person, the arrested person must first sign such waiver. No? Murag iyang gi-waive ba ang iyang right to file a case against the arrested person because siya mismo nangayo mag-time, enough time, within which he can submit his counter affidavit or nag-demand man siya preliminary investigation. That is always a requirement. If the arrested person wants to avail of his right to a preliminary investigation, mo sign sa siya waiver of Article 125. They go hand in hand. If the arrested person does not sign a waiver, then he cannot avail of his right to preliminary investigation. Take note, however, that for crimes punished under the Anti-Terrorism Act of 2020 or Republic Act 11479, this is a new law. A suspected terrorist can be detained for a maximum of 24 days without violating Article 125 of the RPC. Meaning to say, since 24 days man ang gihatag sa balaod for law enforcers, no, to submit the arrested person or bring the arrested person for purposes of inquest before the fiscal, even if they bring the suspected terrorist before the fiscal for purposes of inquest beyond the 36-hour reglementary period, they will not be violating Article 125 of the Revised Penal Code. Because under Section 29 of the said Anti-Terrorism Act, explicit man dito, no, clear man dito nga, they will not be held liable under Article 125 because they can detain the suspected terrorist for a maximum of 24 days. Now, what are the crimes that can be the subject of preliminary investigation? Number 1, all crimes where the penalty imposable is at least 4 years, 2 months, and 1 day. All crimes punishable by imprisonment of less than 4 years, 2 months, and 1 day where the fiscal believes that a preliminary investigation should be conducted. Now, unsa may difference aning duha? In number 1, it is a matter of right. So, kung ang penalty imposable for the crime alleged to have been committed by the arrested person is punishable by at least 4 years, 2 months, and 1 day, makademand ang arrested person sa iyang right to preliminary investigation as a matter of right, provided that he executes a waiver of Article 125. But kung ang charge against or ang gikiha against the arrested person is a crime which has a penalty imposable of less than 4 years, 2 months, and 1 day, his right or his desire to have a preliminary investigation will not be considered as a matter of right. No? Okay. In crimes where the penalty imposable is less than 4 years, 2 months, and 1 day, a preliminary investigation is not a matter of right. But if the fiscal believes that a preliminary investigation should be conducted, then well and good, no? The fiscal will conduct a preliminary investigation. And number 3, all crimes committed by public officials in connection with the performance of their official duties and functions. What if the arrested person does not opt for a preliminary investigation or refuses to execute the said waiver? The fiscal, in such a case, shall proceed with the conduct of the inquest, notwithstanding the absence of counsel, by examining the sworn statements of the complainant and the witnesses and other supporting evidence submitted. Now, if the inquest prosecutor finds that probable cause exists, he shall forthwith prepare the resolution and information for filing in court. Can an inquest be conducted beyond the 12, 18, or 36-hour reglementary period? The general rule is no. In such a case, the fiscal must order the release of the arrested person, subject to the approval of the prosecutor general or of the provincial or city prosecutor as the case may be. But there are exceptions. An inquest can be conducted even beyond the 12, 18, or 36-hour reglementary period where, or in the case of an inquest that falls on a non-working day, Saturday, Sunday, and a holiday, and a prosecutor is not available, the inquest proceeding may be conducted on the first office day following the arrest, even if at the time of such inquest, it already goes beyond the 12, 18, or 36-hour reglementary period provided for under Article 125 of the Revised Penal Code. Another exception is for offenses punished under the Anti-Terrorism Act of 2020 or RA 11479. Since a suspected terrorist can be detained for a maximum of 24 days This means that an inquest may be conducted within such period without violating Article 125 of the Revised Penal Code. Let me show you a sample of an inquest case flow. So, as you can see, here X is a policeman who saw Y kill Z in his presence. X thereafter arrested Y. So the crime committed by Y here is either murder or homicide. X then brings Y before the fiscal for inquest. And then the fiscal finds the arrest valid and proceeds to determine if there is probable cause. The fiscal finds probable cause and then prepares the resolution and information. And then after preparing the resolution and information, the fiscal then files the information in court. Now, since the crime committed by Y here is murder or homicide, it is considered as a grave offense. And for purposes of Article 125 of the Revised Penal Code, for grave offenses, the reglementary period is 36 hours counted from the time of the arrest. Now, the rule requires that the inquest proceeding, to include the filing of the information in court, must all be completed within 36 hours. Otherwise, if no information is filed after the lapse of the 36-hour reglementary period, the person or the arresting officer having custody of the arrested person is obligated to release the arrested person. Otherwise, the arrested person may be held, rather, the person having custody of the arrested person may be held liable for arbitrary detention under Article 125 of the Revised Penal Code. Now, let us say after the fiscal finds the arrest valid, or after the fiscal receives the complaint filed by the police officer, the fiscal finds the arrest not properly effected. What shall he do? He shall then order the release of Y in this example. Or if the fiscal finds the arrest not properly effected, but the evidence on hand warrants the conduct of a regular preliminary investigation, the fiscal shall still order the release of the arrested person, but he will proceed to conduct a preliminary investigation, since he finds some evidence to continue with the investigation. Or if the fiscal finds the arrest valid, but Y, the arrested person here, desires to avail of a preliminary investigation, Y must first sign a waiver of Article 125 of the Revised Penal Code. So, as you can see here, this is a sample inquest case flow which sort of summarizes everything we have discussed in this video. One final question. What if the fiscal is absent or unavailable? What shall the arresting officer do? In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. That is so provided in the rules in Section 7. The proper court here means the trial court that has territorial jurisdiction of the place where the crime was committed. So, let us say the crime was committed in Ormoc City. The trial court that has jurisdiction in Ormoc City is either the Regional Trial Court of Ormoc City or the Municipal Trial Court in cities of Ormoc City, depending on the nature of the crime committed, such that if the crime committed has a penalty imposable of more than 6 years, then it is the Regional Trial Court of Ormoc City which is considered as the proper court. Or if the crime committed has a penalty imposable of not more than 6 years, then it is the Municipal Trial Court in cities of Ormoc City that is considered as the proper court for purposes of filing an inquest with the proper court as so provided in Section 7 of Rule 112 of the Revised Rules on Criminal Procedure. That is, when a fiscal is absent or unavailable. That is the only instance where the arresting officer or a private person may file the complaint directly with the proper court. So that ends our discussion on inquest. If you have questions with respect to the video or to my discussion, please feel free to hit the comment section. And of course, don't forget to like, share, and subscribe. Thank you.